There is going to be next panel, and my friend Divya and colleague Divya is going to take over from here. And please be seated. The tea break is not yet, it is after the session. So please be seated and enjoy the session.
For our first panel discussion for today's event is on the relevance of mediation in cross-border disputes. Cross-border disputes, especially commercial cross-border disputes, assume substantial significance in today's world, owing to the dynamic markets across the territories enabled by information technology and artificial intelligence. These disputes bring with them a unique set of challenges with an interplay of territorial, language, and cultural barriers. And the answer to its effective resolution may not lie in a conventional legal dispute resolution mechanism. The panelists for our first panel discussion are not only thought leaders in the realm of mediation, but have extensive experience in resolving cross-border disputes and have been contributing towards building a robust mediation ecosystem around the world. Our esteemed panelist, Mr. George Lim, Senior Counsel, Chairperson of the Singapore International Mediation Center, our esteemed panelist, Mr. Wee Ming, CEO of the SIMC, our esteemed panelist, Mr. Gregory Vijayendran, Senior Counsel, Partner of Rajah Tann. Our panelist, George Lim. Mr. Lim is the chairman of Singapore International Mediation Center. He served as the president of the Law Society of Singapore between 1998 and 1999 and was appointed as a senior counsel in the year 2010. Mr. Ling was Singapore's mediation consultant to UNCITRAL Working Group, which led to the adoption of the Singapore Convention on Mediation. He serves on the dispute settlement panel of the Comprehensive and Progressive Agreement for the Trans-Pacific Partnership. Mr. Lim has mediated more than 700 disputes and has extensive experience in mediating cross-cultural, cross-border disputes in Singapore, Thailand, Taiwan, Maldives, South Korea, and Australia. Mr. George has also conducted mediation training for judges and lawyers across the length and breadth of the globe. In 2020, Mr. Lim was awarded the Public Service Star by the President of Singapore for his contributions towards mediation. In 2002, he was named by the International Who's Who of Commercial Mediation as a global thought leader in the field of mediation. Our next panelist, Mr. Wee Meng. Mr. Wee Meng has over 30 years of experience as legal experience and has worked in Beijing, Hong Kong, Sydney, and Singapore. He spent about 20 years as General Counsel of IBM, Greater China, and Nortel Networks Asia Pacific before joining SIMC. He's currently leading SIMC to resolve complex commercial cross-border disputes in the Asia Pacific region. He's an accredited mediator of the Singapore International Mediation Institute. He graduated with a law degree from National University of Singapore and holds a Master of Law from the University of Hong Kong. Our next panelist, Mr. Gregory Vijayendran. Mr. Gregory Vijayendran is a partner in the Singapore law firm Rajah Tann, where he specializes on arbitration and conflict resolution, as well as commercial and civil litigation. He was appointed as a senior counsel in 2019 and has been recognized for his works in the domains of insolvency, restructuring, and reorganization law. Mr. Vijayendran was admitted to the Singapore Bar in the year 1993 after graduating from the National University of Singapore. He's also regarded as a champion of pro bono work, having received the Law Society's inaugural Pro Bono Ambassador Award in the year 2009. He's also the chairman of Law Society Pro Bono Services, which provides legal aid to the community and organizations that assist the poor and vulnerable. Mr. Gregory is a part of the SIMC panel of specialist mediators and has been involved in numerous high-value cross-border disputes under the auspice of SIMC, including those with the Indian parties. He also serves on the SIMC Board of Directors. I may now request our moderator, Ms. Ektha, to start the session.
With the mediation bill now pending before the Parliament and with the Singapore Convention that was signed in 2019, there's been a renewed conversation on how we look at cross-border mediation and where does, especially in commercial disputes, how do we look at mediation making an impact. And Singapore actually has been one of the early adopters of mediation and looking at mediation not just as a standalone thing, but also integrating mediation with other forms of dispute resolution, whether it's through ARB, etc. And you've been there, and it's been several years, whether at a domestic level with SMC and international level with SIMC. How has the response been, and what has been your experience? George, if you can, share your experience, and then Wee Ming as well.
Okay, thank you. And first, let me say how happy we are to be here in Hyderabad. For me, it's my first time, but I think I've gained weight already. The last 2 days, I think I've gained like 5 pounds. But it's been a happy experience. And Justice Ravindran, thank you for that address. My wife is very happy with what you said. And you know the saying, you either want to be happy or be right. If you want to keep your marriage happy, choose, right? Okay, cross-border disputes and mediation. I think before that, let me just try and lay the foundations. So mediation was formally introduced in Singapore in the 1990s. It started off in the courts because there was a backlog of cases, and my Chief Justice then and the Attorney General said, look, we need to do something about it. So mediation was introduced in the courts. We have two principles at that time. One was to help clear the backlog so that people have access to justice, so that judges and courts can focus on hearing the more important cases. The other principle was culture, which Justice Ravindran referred to. You wanted mediation to be used and practiced by society. And so with these two principles in mind, the way we did it in Singapore, and there could be pros and cons, was in the subordinate courts at that time, the lower courts, mediation was practiced, well, the cases were mediated by magistrates who were trained in mediation. Many of them were trained in Harvard, were good mediators. But if the case was not settled, they would not hear the case. So that's a distinction. And success rate was like 90%, I think, okay? It was free so that people had access to make it popular and in use. Then in the higher court, where the cases are more complex and claims are larger, the judges will not mediate the cases, but will refer the cases to the Singapore Mediation Center. And I'm a founder member. Seng-On, are you still here? Okay, Seng-On was our executive director. So at the Singapore Mediation Center, the cases to be heard by lawyers and non-lawyers. We had a panel of about 100, half lawyers, half non-lawyers. We had architects, engineers, doctors, okay. And I think that model went well for us for many years. And then in 2013, my Chief Justice Sundaraj Menon, and our Minister of Law then said, look, SIAC, I mean, many of you know about SIAC, right? SIAC, the arbitration center, was doing well. And he said, look, we need to provide people with a mediation service in cross-border disputes. So he set up a working group. I co-chaired it with Edwin Glasgow QC, now KC, and we recommended the setting up of a Singapore International Mediation Center. So we've got two main mediation centers in Singapore. One focus on domestic, one focus on international or cross-border disputes. And that has worked well because historically that's how it's happened. You have an advantage now, IAMC. You've got arbitration and mediation center. So I think you can really move faster because it's one body doing it all. Whereas we work closely in Singapore, but because historically we've got two mediation centers and one arbitration center. But it has served us well because in terms of focus, SIMC, we are still a young body, 8 years plus. We've developed. I think our focus has been really to help people look at international mediation. And I can say, hand on heart, we are now attracting cases unconnected with Singapore, large claims coming in. It has benefited the legal profession. It has benefited people around the region. Okay, so I just want to lay that foundation and maybe let either Wee Meng or Greg further the conversation.
How have you looked at the progression? So George set out how mediation developed in Singapore from the 90s, and moving on to cross-border as well. And you have SIAC, you have SIMC. We talk about mediation as a standalone dispute resolution process, but you've also integrated it very well with SIAC and made it through ARB, Med-ARB or Med-ARB. How has that gone on? While we'll talk about mediation exclusively through SIMC, but there's also been a synergy with SIAC. And for disputants who've not looked at mediation as part of their contracts, just saying that let's do mediation, and every agreement we find with arbitration clauses. How have you seen that progression?
Hello. Let me first of all thank IAMC for inviting us. A great honor for us to be here. And when I listened to the four justices, I realized that you already have very good mediators amongst you, because it is very much in your blood to mediate. And I'm going to ask Justice Ravindran for a copy of your speech so that I can show it to George's wife. So if I may be allowed to just start with a quote, since it's India Mediation Day, a quote from the great Mahatma Gandhi. He said, "Peace is not the absence of conflict, but the ability to cope with it." I think it's a beautiful quote. Peace is not the absence of conflict, but the ability to cope with it. And this is what we do in mediation. We cope with the conflict. We help the parties to cope with it. We help the parties to resolve it peaceably. Maybe I can also share from my experience in SIMC how it has grown over the last few years. My experience with mediation actually started as General Counsel for IBM. I think that was part of the introduction. I started my career as a lawyer in litigation. So for many years, I was fighting for my clients in court. I then went in-house with IBM, and I've never heard of mediation before that. Really, hand on heart. It's always been fighting either in court or in arbitration. And because I was General Counsel for China at that time, we had a lot of disputes. And I first encountered my first case as a user, where we had a very complex... Hyderabad is the, I think Tariq was telling me, is the Silicon Valley of Asia. And you have a lot of tech companies here. So I think you understand the kind of issues that tech companies may have. So I then realized that for a lot of these tech companies, the kind of disputes that you have, that we had in IBM, actually can be resolved very effectively by mediation. So that was my start, and I had my first case, which I thought would not be mediated because I'm a litigator, but it was successfully mediated, followed by a second case, followed by a third case. So my success rate as a user is 100% for mediation, which is great. Thank you. And I'm sure you will see that here in Hyderabad as well for your tech companies. So for SIMC, when I came into SIMC, I did not have that much experience in mediation. But as a user with IBM, I knew the benefits of mediation. I knew the benefits of cost, time, relationship, certainty, that I think has been very well presented by all the speakers. And I experienced it as a user of those benefits. And so when I came on board as a CEO of SIMC, I was a believer. I was converted. And over the last 4 years, indeed, we have seen a tremendous growth of mediation. I think George will talk about that later in his presentation, where our caseload has gone up by almost 4-folds. And not only case numbers, of course that's important, but really the complexity of the cases that we have seen over the years the value of each case that comes has also gone up. And more importantly, we've managed to keep the success rate of mediation at more than 70%, which is really a great thing that we are able to service the users that we work with, because they find satisfaction at the end of the day. Even those 20 to 30% that did not get settled, they also found it very useful to have the mediation. So one of the things that we did in SIMC that you mentioned, Ektha, is really AMEDA, right, with SIAC. So we have a protocol with SIAC, and this is really a very elegant solution, I think, where parties will first file their matter with SIAC for arbitration. Then immediately the case gets referred to SIMC for mediation within an 8-week window. And within that 8-week window, the matter is either resolved, and then they can go back to SIAC to register the judgment. But in many cases, the parties did not feel that they need to go back to register the judgment because it's consensual. They do not need to register the award because it's consensual. So the settlement is complied by the parties. The parties actually committed to it, and they enforced it themselves. So that was what we've seen in AMEDA. In a very small window of 8 weeks, the matter can be resolved very quickly and efficiently. If you think about arbitration, that's really just an adjournment of an arbitration. So we were very happy to be part of that process. Thanks.
Thank you, Meng. Now, the other side, and lawyers play an integral role or an important role in any conflict. And I remember when I started my mediation journey, there used to be this, to bring in an element of humor, we had the form of ADR, which meant alarming drop in revenue. And lawyers were like, is there something that is really necessary? Do we need to pause an adjudicatory mindset that we have and move into, and Meng, you may said that you were converted because you had a 100% success rate, but a lot of lawyers don't necessarily think that way. But since the evolution of mediation in Singapore since the 90s, Gregory, being part of a law firm and being on the other side, not as a mediator, not as a party, how have you seen the evolution of the legal community in adopting mediation as a tool for dispute resolution?
Thank you very much for asking that question. Once again, joining my colleagues, George and Wee Meng, to commend IAMC for the wonderful organization of this inaugural Mediation Day, India Mediation Day, and to bring you greetings from Singapore as well. And to just complement what my colleagues have touched on, and George has laid the framework. I think we've seen this journey from the 90s, when I was a junior lawyer, all the way through to the present. And there's been a cultural shift. You see that cultural shift because when mediation was first introduced, you would have the lawyers who are lukewarm, some that may be positively resistant, and of course you have the reluctant embracers, and you have the champions. And over time, we've seen that actually the message has spread like wildfire. I liked your colorful description of ADR as alarming drop in revenue. Perhaps a few of the detractors might have been afraid of that. But we've actually seen that hasn't happened, but that instead there's also been an economic imperative. And what do I mean by that? In the case of, for example, institutional clients, and I think Wee Meng has shared a rich example from an in-house perspective, many times when you're able to resolve the case fast and resolve the case in a cost-effective manner, that's not true for every case. In some cases, you do have to take the point on, either because of principle or because there is definitely no consensus to try and resolve it. But there will be cases that can be resolved early, that can be resolved in a cost-effective way and in alternative ways. And we saw some wonderful creative examples in the training that we've done. And so when that happens, the client who is able to have closure and be able to move on and be able to find a way to resolve their own time involvement in the case and reduce the risk of uncertainty, will then actually be able to remember that as a milestone moment for the company, which then becomes a point of reference for recurring work for the lawyer. And so from an institutional client perspective, and it's true for individuals as well, but more so for the institutions, we have seen, I think, repeat work. We've seen, the reputation of lawyers also grow as problem solvers, as lawyers who are able to think in terms of the client's interests and to put that, in the forefront. To undergird that, and this is to add a bit more of a, sort of complete picture on the entire milieu, there have been some other levers too. One of them is, ethical. So there is an ethical rule in our professional conduct rules that obliges a legal practitioner in an appropriate case, together with his or her client, to evaluate the use of alternative dispute resolution processes. So that has been one lever. Another lever has been procedural rules as well. And in the landmark introduction of revisions to our procedural code last year, there is now a duty on clients, not just lawyers, on clients to consider amicable dispute resolution. So we know ADR, appropriate dispute resolution, or even alternative dispute resolution, but now it's part of one of the offerings in terms of amicable dispute resolution. And there is a duty for litigants to consider that even before you file a case. But what if you don't want to do that? What if your lawyers transgress? Then the court, under the powers afforded in the procedural code, can actually take that conduct into account in terms of any refusal to submit to mediation or the conduct of the parties to actually make certain orders on costs in the end game. And so these are part and parcel of the aspects. But it's not just about a stick, it's also about the carrot that I mentioned. And so we've seen this grow in a phenomenal way across different sectors, across different verticals. And today, the Law Society, and I was serving as the Law Society president, we embraced this whole move as well. And there is a mediation committee. There is a Law Society mediation service that was launched in 2017. Chief Justice Menon came to speak about the link between mediation and rule of law. And we've seen that grow in terms of offering as well. But certainly the work of SIMC and the special place it has in the overall ecosystem in international commercial mediation has also brought about a further dimension in terms of the lives of practitioners.
So let me, because your question to us was the relevance of mediation in cross-border disputes, right? So can I address that with an actual example?
Of course.
Okay, so this was a few months ago. I mediated a case. Indian party, Japanese party, a venture, okay, I got to keep some confidentiality, in an Asian, energy plant in an Asian country. Dispute, all right? They all flew into Singapore to have their case mediated. And when I saw them, I asked them, why did you choose mediation? For the business person, it's so clear. I don't want to get bogged down with litigation or arbitration in India or in Japan or in that other Asian country, okay? Just very practical reasons. The plant is still working. We need to sort this out. Otherwise, we will lose the entire investment. We cannot wait a year or 2 years or 3 years. So it's very practical reasons why they come. They set the mediation for 2 days, okay? You know, if we go to court, many of you are lawyers here, right? Can you have a raise of hands? Lawyers? Yeah, many of us, okay. You know, and judges too, when we go to court, what do? We try and reconstruct the past. What happened 2 years ago? Who breached this? Who breached that? What are the damages? Okay? In this case, in mediation, we say we look forward. What are we going to do about the problem? And the obvious answer was a buyout. We spent 2 days not talking about the past, but about the correct price, a fair price. And we resolved that within 2 days. They shook hands, they were so happy, the project went on. So if you ask me about the relevance, this is it. Particularly in cross-border disputes, where do you go to get your case heard? Arbitration or litigation? The time is so important for business people. And that's why mediation becomes an obvious answer for them. And that's why it's taking off. And it's so relevant. And I'll tell you guys, get involved. Yeah.
But George, in fact, you just mentioned you had a Japanese party, you had an Indian party. culture becomes also critical when you're looking at these. And I know in the second mediation training that you just had, there was a lot of emphasis on culture, language, when there can be barriers and how do you approach them. And I remember when I did a 2019 training with SIMC, I remember you talking about how in an opening statement, you really try to understand the parties and where they're coming from and look at identification. When India is also now moving into embracing mediation in a larger way. So how do you think India and Singapore can work together to improve an understanding of culture, language, so that when we have cross-border disputes, and Gregory, I'll come to you when we look at how do lawyers, get involved in that. Because as mediators, as part of our training, we look at culture, we look at language, we try to at least understand things. So how can we collaborate as countries together to understand some of these cultural balance? We may, yeah?
So in our 2-day training, we had really very good participation from everyone. We talked about how the Indian culture is different. And not only that, we talked about how the culture in the different states are different. So we learned from you as much as you learned from us. It was a very good exchange. And we talked about a dispute from one city to another city in different states. It's actually a cross-border dispute. It's a dispute between 2 different states. And we realized that because of your inherent comfort and you're so used to moving between different cultures, the Indian mediators will be very suited. And of course, your English language is very strong. And all international disputes are conducted in English. You would be very good, very suited for international disputes. And in that sense, Singapore is very similar. Singapore, we have different races. We're very comfortable with English. Of course, we have other languages as well. I speak Cantonese, I speak Mandarin. So I think the combination of India, Singapore will serve the region very well because of our natural cultural comfort, our fluidity moving between cultures and languages and customs. And you think about the trade between India and Singapore, it's just tremendous trade between the 2 countries. There's also tremendous trade within Asia itself. So I think within Asia, we can certainly work very closely together to see how we can promote mediation with the language skill and with the cultural affinity that we have.
Thank you. You want to add? No, Gregory, so since, while we talk about as mediators, we understand culture, but sitting as counsel along with parties, and especially in a cross-cultural dispute, how can lawyers, and how could lawyers with India and Singapore, again, collaborate with each other to bypass or to overcome some of these cultural barriers, and what's your experience been so far?
Thank you very much for giving me the opportunity to share some perspectives. And I'm going to share from an example involving co-mediation. And maybe this might inspire some thought and examples. This was the inaugural case between the Singapore International Mediation Center and the Japan International Mediation Center. And of course, we won't go into confidential aspects, but there was an Indian party and there was a Japanese party. Different case. Yeah, so I didn't encroach on George's stuff. But and so there was, one co-mediator appointed, on the part of SIMC and JIMC, and I co-mediated that with a Japanese co-mediator, senior Japanese lawyer. The case was actually set down for 3 full days of mediation. There was litigation everywhere, India, Japan, so on, heavily lawyered, very competent counsel, and basically the 2 of us were co-mediators. We were doing all this online, and so of course that meant we were very careful, intentional to try and spend time pre-mediation to get to know the parties, to build the comfort levels, ensure that the chemistry was appropriate, and so on. so that we could prepare them. You can't just go in cold on the day of the mediation, especially in an online panel where we don't have the chance to interact in person like this. We were able to see that there was a lot of cross-cultural understanding that we could forge. And you can imagine the differences. Common law on the part of India and civil law on the part of Japan. You've got different nuances in terms of culture. The need, for example, to give face to the East Asians. And understanding some dimensions of this. Language, the fact that my Japanese co-mediator could speak Japanese was a plus because he could then converse with some of the decision makers on the Japanese side, with permission, of course. So through it all, we resolved it in 2 days. We didn't even take the full 3 days. And we were able to see that we could actually use this in a small way to create some understanding of different cultures and different nuances of legal systems, and also cross not only geographical barriers, even technological barriers, and try and bring people together. And so with the Indian lawyers, as Wee Meng has very astutely pointed out, you're very conversant in English, and it's a lingua franca in the legal system globally. And so with that power, with that asset, and with the brilliance that we saw in the last couple of days, the team of specialist mediators, partner with us. Try and do a co-mediation, because 2 hits are better than 1, and in many ways we can avoid any blindsiding and try and resolve and bring in our best talents together, particularly when it comes to specialist areas which may require domain expertise. And so, for example, if it's an intellectual property case, perhaps you can work together with an intellectual property expert and co-mediate and try and see how you can bring the best in terms of language and culture. And this is one small way that we are contributing to actually international peace as well, by resolving that problem in that little corner of the world together.
And I think at a global level, this conversation also started with the Singapore Convention. So now when we see the Singapore Convention, it was signed in 2019. Now we have 55 countries which have signed. Early last month, UK also, after their consultation, indicated they would also sign the Singapore Convention.
Sign and ratify.
Yeah, sign and ratify. And we've already seen, with Uruguay ratifying it, now we have 11 countries which have actually ratified the convention. There's a future to how we now look at international commercial disputes, enforceability across geographies. Singapore was one of the first signatories, the first one to ratify it as well. So far, what has your journey been? As part of an SIMC, as an institution, how do you see that? George, as somebody who's been part of the conversations to get the Singapore Convention where it was, and we can end this discussion with seeing the future of cross-border. And Gregory, you as a counsel, you've had experience with Japan and India through SIMC, through Singapore. Going forward, how do you see as a counsel the Singapore Convention? So Wee Meng, we could start with you, and then George and Greg.
Before coming to India, I was in Riyadh last month, and there's a lot of excitement in mediation, and I know Middle East is a very big business partner, trading partner with India. Saudi Arabia has signed and ratified. They are really taking off in terms of mediation. Then in between, I went to China. Again, massive economic power. They have signed, and they're going to ratify soon. So I see this right across the different regions. We're going to Japan, we're going to Korea. So I think that a lot of countries have seen the benefit of how the Singapore Convention can help. And certainly as a user wearing my hat as IBM, is very obvious, like George has said. I think the question to me is where mediation is going. I think the convention in 2019 is a watershed moment. It is a milestone that everyone will look back and say, this is the beginning of something wonderful, because it gives legal force to a settlement agreement. And as it grows, I think more and more countries will sign. But let me just also make a quote from our Chief Justice Sundaresh Menon, where he said, and it was during the India-Singapore Summit in 2019, I think some of you may be on it, and it was wonderful to have Chief Justice Ramana as well as Chief Justice Sundaresh Menon, where Chief Justice Sundaresh Menon said, we stand on the cusp of mediation's golden age. We stand on the cusp of mediation's golden age, and I believe that we are really getting there. And if India could sign and ratify, India has signed, if India could ratify, I think it would really signal to the world that you are serious about how India will progress in this area of mediation. And let me just close with something on a personal note. I think mediation, of course, is very good for business. It's very good for me participating in it. But it has also made me a better person. It made me a more peaceable person. And there was one of the party that said to another party at the end of a very long mediation, he said, pointing to the other side, he said, I don't know whether I have a friend, but I certainly have one less enemy. I think that's so powerful. And I think that's what we strive for. We want a more peaceable society. We want to relate to each other as human beings, as fellow human beings, and for more relationships at the end of the day. Thank you.
Greg, you want to say something? You want me to come to you? Do it.
Okay, yeah, let George have the last word. But I would also add some points to this, because I think the Singapore Mediation Convention, of course, George is the guru, and there's so much that we can talk about that itself deserves like a day. And we know that there are aspects of it that provides both a sword and a shield for enforcement, and a shield to invoke a settlement agreement to prove that a matter has already been resolved. And there are many other facets, to consider, which, I think for us as lawyers, we would love, analyzing it from the perspective of, compromise and the nature of the international commercial mediation settlement involved. And I think it will grow in terms of importance. We know that the UK government, for example, is also now agreed to sign the convention. And that itself, from a major international power, just basically issuing a statement of that nature also builds a certain momentum. And so we see this as growing, and there is an excitement and there is a buzz. That also means the potential for lawyers to be able to explore international work in this space, both in terms of counsel role and in terms of mediator role. And mediator role, of course, we can see potential for co-mediating and then growing and learning together. So that creates another stream of revenue, really, from the perspective of lawyers, where it's indispensable that you need to have mediation skills today. It's one of the valuable tools in the 21st century lawyer's toolbox. You can't live without it. You can't respond to a client and say that, I do litigation, I do arbitration, but you know what, I don't do mediation. You'll be an incomplete lawyer. And the juniors are crying out for it. The juniors are crying out for training. The juniors are being trained in terms of mediation advocacy. It's the wave that we all need to ride on. And I see that wave as growing. And I think in terms of the aspect that I also want to surface, and I'd written about this in a message as Law Society President called The Lawyer as Healer. I'm not going to go through it. You can Google it. It was probably one of the best received messages I've ever had in terms of responses from judiciary and lawyers and so on. But I quoted our Chief Justice Sundaresh Menon, where in one vertical in terms of practice, which is family law, but it isn't just limited to family law, he described the role of a lawyer as a peacemaker. And there he said, that part of the role of a lawyer is as problem solver, working collaboratively in a multidisciplinary environment with the objective of achieving outcomes that are beneficial to all those involved in or affected by the dispute. And I leave you with this quote, which I found very meaningful. It comes from the great Mahatma Gandhi. And in his autobiography, he said this, I had learned, and I quote, I had learned the true practice of law. I had learned to find out the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite parties riven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul." Unquote.
Okay, I know we are behind time. So let me just say, because you asked about the impact of the Singapore Convention. So I was in New York 2 weeks ago. It was Working Group 3 on investor-state disputes. This is a big problem in the world now. All right, investors coming to the state and they have problems with the government. Who's going to hear the claim? Right. And I was speaking on behalf of SIMC to promote using mediation early to salvage the investment and the relationship of the parties. Now, this is the change I've seen. 10 years ago, governments did not talk about mediation. But Singapore Convention was signed in 2019. And 2 weeks ago, we had 120 representatives from governments. And we were talking about mediation. That is the change. So Justice Ravindran, you talk about knowing mediation. At least we are the first step now. People are knowing, hopefully we will remember it. But people are knowing it. People know it now. Governments are talking at that level. Greg talked about a wave. The wave has come. Ride the wave. Thank you.
Thank you, Wee Ming. Thank you, George. Thank you, Gregory. I think the future is in mediation. Mediation cannot be ignored as a dispute resolution mechanism, and lawyers being problem solvers, looking at international means and mechanisms for dispute resolution, especially as the Singapore Convention catches on and we have more countries signing and ratifying that. Thank you once again.
Thank you so much for the wonderful discussion, taking us through the intricacies of cross-border disputes and the opportunities lying there under, especially for India and Singapore to be at the helm of affairs. And we hope that the India will soon ratify the Singapore Convention. And meanwhile, we all look forward to learning and implementing a harmonious way of resolution of disputes. Thank you so much, honorable panelists and a moderator. I may now call Mr. Suadat Ahmed Kirmani, Dispute Resolution Practice Tatwa Legal, to give a token of appreciation to Mr. George Lim. One after. Appreciation to Mr. Wee Meng.
Wow, I feel so honored. Thank you.
Thank you. I may now request Ms. Sunaina, Associate Counsel IAMC, to give a token of appreciation to Mr. Gregory Vijayendran.
Very high honor. Nice color.
Ms. Sunaina, my hand over token of appreciation to our moderator, Ms. Ektha, who did a wonderful job moderating this beautiful session. Panelists for this wonderful, insightful session.